Welcome to Property Chat. My name's Roland Taylor. Some of you may remember me from my days when I was the Managing Director of Statewide Conveyancing. These days, of course, I'm a lecturer at the College of Law. Today we're going to be talking about the new seller disclosure statement, and with me I have Bethel Campbell, who's currently a Director at Statewide Conveyancing in charge of the property division, including conveyancing, and I have Lloyd Stanger from Mackay Solicitors. He's the Director in charge of the property law division, including conveyancing. Welcome, guys.
Thanks, Roland. Thanks for having us.
So, the disclosure statement. Big change, of course. Filling it out, it's going to be a little bit tricky, isn't it?
It is going to be really tricky, I think, but from my side of things, and I'm not sure where you're at with it, Lloyd, but it feels like a lot of admin work, and I think that's going to be the hardest thing over the next couple of weeks, is everyone just getting the hang of it. But once they've got their processes in place and they understand the form, I feel like in another couple of months' time, it's just going to be second nature. Yeah. So getting to that point is going to be the hard bit.
I agree, Beth. Like it's realistically the same things that are already in the contract. There's not really anything too dramatic in terms of the changes. It's just posing those questions to the seller and making them answer it before they go to contract.
Well, let's go through the form and maybe address some of the issues we think may come up. So the first one that I have for you is filling out the property details. What if it has two addresses?
I can take this one, Lloyd, if you want. My opinion on that one, Roland, quite simply, use whatever's on the rate search.
Great. Let's look at encumbrances. So what is an encumbrance and what's a registered encumbrance and what's an unregistered encumbrance?
You'd think that'd be an easy answer, but it never is. And I do feel bad for agents because it can be really overwhelming. We have junior lawyers that often don't understand these differences. Did you want to take a registered encumbrance, Lloyd?
So a registered encumbrance, I think everyone's fairly familiar with that term. It's generally looking at your title searches once you've received them back, and if there's any leases or if there's any easements there, they need to be recorded as a registered encumbrance. So anything on the title, as you've seen before, that isn't a mortgage is essentially having to go in this seller disclosure as a registered encumbrance.
What are statutory encumbrances?
It is allowing typically a government body to have access and to have services on your property. So that would be things like telecommunications, sewage pipes, water pipes, electricity, but they're not going to be noted as an actual registered encumbrance because it is under a completely different area of a particularly different contract of law. So
these are a bit harder to get a hold of because obviously they're not going to show on your title search. So we're going to have to do a different search here in order to disclose these things. But again, this isn't a new concept. It is probably a concept that currently needs to be looked at in the existing versions of the REOQ contracts. It's just now turning the seller's mind to it. And the easiest way to get a hold of all of those statutory encumbrances is to do a dial before you dig search.
Yeah, the other one, of course, is you can do My Maps, and each council has a different name for it, where it brings up all the infrastructure.
Yeah.
Yeah, there is. There's also another external one that we've been looking at in our office, and I'm not sure, Lloyd, if you come across it, but there's a Develo search that you can order. That's about $2 per search, and it actually gives you all of the information apart from telecommunications. So that is something that we've certainly been looking at our team, that may be something really easy for people to access all of this information, because we do find sometimes the dial before you dig information, it can be quite cumbersome when it comes through and really difficult to actually collate together. So that is one search that we are looking at from our side of things. So.
Now, reading these searches is not the easiest thing in the world, right? So let's say you get a search back and the search shows a sewer main that runs near the property or in the property, and you've got connections going to and from it and all these lines over the property, right? How do you recommend filling out the disclosure statement in regards to statutory encumbrances?
From my side of things, attaching the search is going to be the most easily identifiable one. So you're not going to miss anything. You're not going to, incorrectly describe it. Attaching that information to your disclosure statement is going to be the easiest way, from my opinion.
And reference the attached.
Yeah, just say refer to the
attached plans.
Yep. And I guess tick the yes, if you're in doubt, tick the yes box and refer to the search.
Definitely, yeah. And our advice is really going to be, you're going to be ordering that search, or you're going to be checking that on every single property, because you just don't know. Most of us forget when we bought that there is a sewer line for council, or there is a stormwater drain for council. It's not things that are regularly on the mind. So we'll just be doing that across the board on every single property, making sure we're getting that information and attaching it to the disclosure statement.
And it changes too with time. So, you know, previously council in Mackay particularly were in a view that if the sewer main ran through the backyard, they would record it as a registered encumbrance, and it would be recorded on the title search. But now they're doing it for every sewer main, no matter where it runs through the property. But going back, say, 30 years, they weren't registered at all. So we've got that fluctuating change in, I guess, government policy based on when and where the land was developed, which is going to mean that it's a little bit different for every property.
So looking at leases and residential tenancy agreements.
Before we jumped on that one, Roland, on the unregistered encumbrance, one that I'm getting a lot of questions over is the unregistered oral agreements, because that's something that I think people are a little bit confused about. So my example that I've been giving to people on the oral agreements has been almost those handshake agreements that they might have with a neighbour to access the bore perhaps, or maybe they just come on and you can keep your cow there, but it's just a bit of a handshake agreement. Use a shared
driveway that isn't necessarily recorded as an easement.
Do these oral agreements, do they pass to the buyer though?
No, my advice legally is no, because they are just a handshake agreement. But of course now we are supposed to disclose them as an actual oral agreement in the disclosure form. So
I think it's just something for agents to be careful of, particularly if it's around, say, an access arrangement, is that you don't want to be selling to say, oh, it's got access to this shed that's in the backyard, when realistically the only way that they do that is through the neighbour's property.
And access is a big one.
Yeah.
Say you get that wrong. Say, the example you gave, which is a good example, the neighbour has a bore, he gives you access, you run a pipe there, right? It's just an oral agreement, right? Let's say you don't note it, right? What are the consequences?
The big thing for me is obviously going to be dispute with your neighbour, because you're going to have this beautiful property, and now you're going to have an unhappy neighbour when you go on and say, I'm going to remove that pipe, I didn't know about it, I'm removing it, you're not legally entitled to have it there, and now I'm ending up with a dispute with the neighbour. And whilst legally there isn't anything in writing, we weren't aware of it, maybe the seller didn't tell the agent, so there may be actual no legal recourse, but you're going to have a very unhappy neighbour, and that's just going to make your life incredibly unpleasant to start with.
So the buyer doesn't have a right to terminate?
Well, I guess if they haven't disclosed it, then you've got issues from that perspective in your disclosure. So I would say that your buyer would have a right to terminate if they found out about it during the contract period.
It doesn't have to be a material effect on the buyer?
Well, if it's their only recourse of water.
True, but if the bore's on their property, then of course there's no prejudice.
Yes.
If the bore's on the neighbour's property, and that's where they're getting water from, then obviously that is...
Yeah, that's going to be
real prejudice.
That's it, definitely. And we found the same with those unregistered agreements in writing as well. Adjustment agreements were the big one that came to my forefront, that people would have with the neighbours that we would then be looking at wanting to disclose, being an unregistered agreement in writing.
All right, moving on to leases and residential tenancy agreements. So, first of all, what's the difference, and how are we going to fill out this form?
I think there's a bit of uncertainty exactly around which part of the form people are going to be filling out for the leases side of things, because that's right, you can see in the top of one of the forms it talks about unregistered leases and gives information on the start date for the rent, the rent amount, the bond, option agreements, but then we have a whole nother section down the bottom for residential tenancy agreements. And of course this form is being used for any property in Queensland, so it hasn't been tailored for residential commercial, it's in exactly the same form. So one line of thinking of course is that the unregistered leases is our commercial leases. So in that section we'd be filling in, that's right, the start date, the rent amount, the bond option agreements for our commercial leases that aren't registered on the title. But then we're going to fill in our residential information if it is just a residential lease. Having said that though, my suggestion probably would be best practice. Even if you have a residential lease, you may want to fill that information in to give as much information to your buyer as possible. But the other problem we have is what if we get it wrong as well? So what's your opinion on that, Lloyd?
Yes, it's going to be one of those catch-22 situations where it's kind of like it's probably a less is more. However, also going back to the fact that this disclosure has to be completed. It's not a substantially complete, it has to be fully completed. So if the onus is on the seller to give as much information as they can as part of this regime, then I would be saying put as much detail in there as you wish to disclose in relation to that lease, but keep it simple. Don't put long-winded clauses or references in there where you're going to have a risk that you're going to come unstuck.
So Lloyd, you were talking about not completing some of the parts, and so what are the consequences? So for example, it's a residential tenancy, they tick the box about the last rent review, but they don't fill in the details about when it starts and the rent. What are the consequences?
Well, realistically, Roland, that information is going to be disclosed in other areas, so it's not going to be consequential in that specific example. But if someone's filled in or left blank a question and then it later, before the settlement occurs, comes about that the buyer uncovers that that information is untrue, then it may be that they're materially prejudiced and they may wish to terminate the contract because the disclosure was inaccurate.
So everyone talks about this term material prejudice. Maybe just for the lay people out there, give us a bit more detail on what material prejudice means.
I'll go back to our easements because that's probably a good one where we can talk about it in that sense. If, say, love this property and I'm going to buy it and my intent is that I want to put a pool in the backyard and I later find out that there's a statutory encumbrance and that there's a stormwater drain, I can't put that pool there, then my dreams are shattered in owning that house. I'm materially prejudiced because the purpose of buying that property was that it had the area for the pool and I can no longer buy it for that purpose.
And so I often say in the simplest form, that's right, if I knew the truth, I wouldn't have bought it.
Yeah, no matter how much compensation.
No, I wouldn't have bought it.
Wouldn't have bought it. But if I would have still bought it, just got a price reduction, I'm not materially prejudiced.
Yeah, doesn't suit me anymore.
So let's move on to zoning. Now this is a tricky one. We haven't really had to do this previously. So Bethel, talk to us about filling out this zoning section.
I think this is the one that people are very nervous about because a lot of the zoning information in theory is widely available. We've got lots of resources from some of the councils to some of the online search platforms that you guys as the agents do use to fill it in. But there's also a concern that a lot of times it's not 100% correct. So if you weren't going to fill something in on it, this may be one of the ones that you actually take the risk on and don't fill it in. Having said that, very rarely for the properties that we are dealing with in the residential space.
Particularly if they're already developed. Probably a little bit different if it's vacant land or, something new where there could be another use for farming or something else that's in there. But anything that's already developed and has a house on it is generally going to be... Yeah,
residential or rural residential or something like that. But if this was one that you were really worried about and you didn't want to go and spend the $2,000, to get a town planning search to 100% verify, this is potentially one that you may get away with not filling in if you were worried. Having said that, if you did use the information you've got available from the local council as a free search or on the other online portals as the zoning, again, if it was residential or it's actually rural residential, it's very difficult, I think, for the buyers in that to say they're going to be materially prejudiced. So.
And I guess it depends on how you're marketing the property.
100%.
So if you're marketing a residential house, it's not really relevant.
No.
Right? But if you're saying, oh, hang on, a potential unit development site, then it becomes more important.
100%. And I think in that commercial space, we're noting that this is obviously going to be a form that's for that residential and the commercial teams, this is something that they're going to potentially have to make sure is right.
Or essentially where the buyer wants to do any development with the site.
Definitely.
Like they want to put a second dwelling or they, want to extend and those types of things. They need to probably look at the zoning requirements, and also have a buyer needs to have a better understanding of what they can actually do with that property.
So I guess with residential houses and units that already exist, a lot of agents are going to probably feel comfortable preparing the forms themselves, particularly after they've done a few. But when we step into the commercial world, maybe that's a time when you go, hang on, let's hand it over to the solicitor. I want him to fill out.
There's a bit more to it in that sense. So yeah, particularly in that commercial realm, I think that it's going to be more involved on the solicitor's end.
Let's look at transport infrastructure. Has this changed? Because I don't think it has, but maybe I'm wrong. What do you guys think?
It hasn't changed. We previously have always had to disclose if there has been a resumption notice, but now I think it's just in everyone's face, the fact that they've actually got to tick a yes/no box. They're really worried about getting the information wrong.
Yep.
But the way that I take it, as a property owner, you should know if you've received a resumption notice. This shouldn't be a surprise of something that you're not aware of.
And it's not like a requisition, say for example with Mackay Council, where it might sit for a while and there's nothing happening or being actioned on it. Once you receive that notice, there's further steps that are going to take place and proceed out. So you will know about the notice being received.
Yep.
Talking about things that haven't really changed, let's have a look at contamination. Has that changed?
I think we're both on the same opinion on that one, Lloyd, aren't we?
No, it hasn't changed.
Again, they've just got to tick a box now, whereas we've always had to disclose contaminated land. But again, it's different with each space. So from our residential space that we're often dealing in, it very rarely comes up that there's a contaminated land issue. But from the commercial side of things, that is something that most of the time the solicitors are checking either at the contract sales before. So we spoke about before that the residential agents may feel comfortable preparing this, but a lot of times your commercial agents may not, but certainly in the commercial sphere, you would be doing that contaminated before you can complete this. But in terms of the disclosure requirements, it's always been the same. We've always had to disclose it.
And in that sense, in the previous regime, if it wasn't disclosed, then the buyer had a termination right. So the exact same thing now applies. So I don't think there's really anything too concerning with the contaminated land, but if a seller is selling a commercial property, I would recommend that they do that search before when they're listing the property for sale.
With contaminated land, I always found this is something where if you use a conveyancer or a lawyer who's very experienced and been around for a while, and both you guys have been in the game a long time, you tend to know what, particularly residential and even commercial, what's likely to be contaminated or not.
Yep.
For example, in Brisbane, Bowen Hills, a lot of that is contaminated. There's all these high-rise residential units built on contaminated land that you have to disclose. Right?
And I think that's the thing. When you've been in the industry for a while, or particularly if you're using an agent that's been in that area for a while, they know, oh, well, that actually used to be a railway station, or that actually was a spray painting or a mechanic or the servo next door.
This used to be a farm and there was a cattle depot. They are aware of that knowledge from that and living locally. So, and just the transactional experience as well from doing other transactions in the area.
Talking about things that maybe changed or maybe haven't changed, let's have a look at trees and heritage. Has this changed?
I feel like a broken record.
No,
it hasn't changed. This was always in the contract, and we've always had to say whether or not, are we having a fight
with our neighbour
at the tribunal stage where the tree's a huge issue and it's causing massive dramas and everyone's having a fight about it. We've always had to disclose that. Now again, it's just in your face. It's a tick box before you sign the contract of sale. Which, it's no different.
Again, used to be a tick box in the contract. So we're just moving the place of where the tick box is.
And I think if you don't know that you're having a dispute with your neighbour over your trees, there's a bigger problem at stake.
Concern,
so you're definitely going to know this information to fill it in.
And then in respect of heritage, again, this has always been a requirement. So there's particular notices and also restrictions on what you can do with properties that are heritage listed. So there is sort of a two-factor regime to that, in that sometimes a property can be heritage listed with council and then it can go to the greater state level. This is realistically only asking from the state level, and generally speaking, you will be aware that your property is on that the heritage listing. So,
and that's a free search as well. You can actually jump online, and it's just a free link to actually check if the property is on the National Heritage Register. So that's quite easy to obtain. So I think, again, if people are marketing their properties, that this is something they think it's a little bit iffy, particularly as you've said, like you've got places in Brisbane. Where they have got whole heritage listed areas. It's super easy. You can jump on, you can have the link, so, and you can check it out.
So they have a section on pools. Now this has always been problematic. Has the pool stuff changed, or is it still the way you recommended it the last 5 years?
it's still the same as it's always been, and that is that a pool safety certificate either has to be provided, or you've got to give notice to the buyer before they sign the contract that there is no pool safety certificate.
And I think one important thing to touch on that is I think a lot of people get confused over the actual council approval for the pool itself and having those council records, but just that the fence is compliant. This is only that the fence is compliant. So if you've got a pool from the 70s that you've got no other information about because it's been there forever and a day, but the fence is compliant, then this is only what it is relating to. It's not requiring the sellers to be providing council history searches for the pool. It's just that the fence is compliant. And I know that we can give that option of saying we're not going to get it, but my advice to most sellers is it's a safety thing. You really want to be comfortable that you are selling the property and that the fence is compliant and is safe. Obviously, we've still got some where we'll be selling the properties as is, without them, but most of the time we're going to have that in place.
Yes, and of course there was that case in New South Wales where a kid drowned in the pool, got into the yard, no pool fence, drowned, and the homeowner was charged with manslaughter.
Yep. And I think that's why this is an important one. It's more about that safety side of things and being confident for you as an agent and also as a seller that you're selling something that is safe and you've got less liability on it.
Not exposing yourself to personal liability as well.
Can you give us a bit of background to owner builders and what are the consequences if it's not disclosed?
I think to start with, to take you back a step, Roland, on that question that's in the form around owner builders, I think when the film first came out, and I think you found the same thing, a lot of people were worried because the start of the form actually says unlicensed building work, but then of course goes on to clarify that's under an owner builder permit. So to take a step back, it isn't overall unlicensed building work. This isn't saying that the shed doesn't have council approval or the lean-to or the slab or any of those sorts of things. This is purely relating to work that's been done under an owner-builder notice. And the disclosure requirements haven't changed. Again, broken record, we've always had to disclose this.
So Lloyd, if it's not disclosed, what are the consequences?
If it's not disclosed, then the liability attaches to the seller. So in a usual scenario where I'm building with a third-party builder, I have QBCC insurance, which covers me for any structural defects in relation to that building work. When you buy from an owner builder, they don't have that insurance. So if Roland's completed the works to the house or his extension to his shed, and I buy from Roland and he hasn't given me that notice, then Roland is liable for the 6 years if there's any structural defects in relation to those improvements that he's carried out under that owner building notice.
So previously it didn't give the buyers a termination right under the contract, it just shifted that liability and actually put it back to the seller themselves personally that they were providing it. Having said that now though, of course, if we don't disclose it on the disclosure statement or we get it wrong on the disclosure statement, whilst that liability will still shift to the seller personally, but the buyer may have a right to terminate now because it hasn't been disclosed on the disclosure statement.
Yes, but I guess the easy one with that is that generally speaking, they are always recorded on the title of the property as well. So if we're doing our title search in our initial sort of opening of doing our seller disclosure, you will have notice that there is an owner builder permit on the property.
It's hard to stuff that one up,
Yeah.
really. It's in black and white on the title. So it is important to know too, obviously, you still do need to give, obviously, further information on that. So it's not just a matter of saying tick, yes, it
Yes.
is. You do then need to go on and actually explain what has been owner built and the information around that. So
Particularly given that this isn't complying with the section of the Owner Builder Act, which the notice is generally given. So you're still going to have to do that separate notice, which you've always had to do, to say this property is affected by an Owner Builder notice, and that's what the work was.
Yep.
So Bethel, you talked about unlicensed building work and council approvals. Let's move on to the next section. It talks about show cause notices, enforcement notices, or a notice given by the council.
Yep.
Let's run through that section.
Yep, and I think this is probably one that people have a little bit of anxiety about, because it's got a lot of words in there and a lot of pieces of legislation that a lot of agents and a lot of people in the industry don't come across very often or understand. So this is a good one. In terms of the first question that's on the disclosure statement there, the first question asks if it's an unsatisfied show cause notice or enforcement notice under the Building Act or the Planning Act. For our sellers, most of them should be fully aware if they've received that notice. If you've received a show cause notice or enforcement notice from council are fully aware that you have done something that doesn't have an approval, it's non-compliant, and they are pushing you to get it done. And it's really got to the point now, if you've got an enforcement notice, council are coming to your property to sort it out or to pull it down. So most sellers will know that first question.
They're also probably threatening other things, like effectively, if you don't comply with this, you've got X amount of days to do it, and if you don't, then we're going to issue you with a fine under the Planning Act or something like that. So that's a really strong notice. Yeah. It's not just this doesn't look right, we want you to please explain. It's a fairly forceful notice that they're pushing out in that sense. And I think that is distinct.
Yes.
There's a clear distinction there between the two notices on the two questions on the form. So don't get them confused. They are two distinct questions. The second then goes more general, where it can be any order. So that first one's purely on a show cause or enforcement notice issue, where you've got a strict time frame to do something and there's a consequence effectively if you don't. The second says any competent authority has given you a notice, which I think is generally a bit broader. But again, your seller should be aware. And one particular that probably raises in my head is a requisition. Agents have dealt with requisitions for a number of years, and they generally pop up during the conveyance, and it's an order that the seller's received, or the seller says, oh yeah, that was there when I bought the property, I forgot about it. So this is, I guess, bringing the question to the front of the seller's mind. So any of those things where when they bought the property there was something on there is kind of turning it to their attention and making sure that they're answering the question. But again, they should know about it.
It can be quite broad though, this one, because the other one that in my mind that I think this could come up is if you've got notices from Ergon, for example, that if you need your power pole, that's your actual power pole on your property, that needs some rectification works to it, those things, because it does go on obviously to say like any local, state, government, court, tribunal or competent authority. So I do feel that, again, your sellers should be aware if they've got a notice from Ergon or the council or those sorts of things, aware of it. Frustratingly, Mackay Council is the only one that does pick up on the rates information if there is that requisition, which is certainly a step well before those shore codes and orders and the enforcement ones we talked about. Other councils really don't have that information. So if the sellers were really worried about that, the only way to check with council is to do a full building record search, which of course is anywhere from sort of, $200 to $500. And we have some councils that they do take 30 business days to actually get us a full record search back. So this one will cause a little bit of concern for some people, depending on the particular property that they're selling. But again, and I think we've spoken about this a couple of times, the seller should be aware if they've got these notices, and by making your vendors actually filling it out and
putting it in front of them.
Yeah, they should be giving that
Turn
information
their mind
to
to it before it's actually going to contract.
And like some of we're talking about unlicensed work and so forth. I remember from my days, you'd do a building record search and it would come up as no file for the house.
Yep.
Now, I guess if it comes up on the building record search, it's not a notice.
No.
It's just coming up, nothing recorded. But if at some stage a letter went out and said, hey, you've built the shed in the backyard, no approval, please obtain an approval, right?
Different story.
Different story,
100%.
and that may be substantial enough to allow the buyer to pull out.
Yep, that's it. And that's 100% right, Ryan. And we've got multiple ones because of age or anything that don't have final inspections because they weren't mandatory before 1998. So 100% that failure to have a final inspection, unless it's gone further to actually council requiring you to do it, isn't going to be caught by that, in my opinion.
Yeah.
So
it's not just a standard council building records issue, I should say. It's more that council have a compliance issue with it and they've taken a further step.
So one bit I actually quite like is rates and rates notices. So now there's actually a requirement to disclose this information, isn't there?
there is, but I'm going to disagree with you on this one. I find this one really strange because it asks about the rates information, but it asks about the water information. Now, so many agents have said to me that buyers actually ask for the water information, which this baffles me a little bit because it all depends on who lives in the property. If you've got 10 people living there all at once. So I did find it interesting that the water information was something that came through. The rates, certainly, I can see why people want to know how much the rates is and those sorts of things. But yeah, I thought the water one was a bit of a strange one as to why we're bothering with that.
And I guess I've seen a lot of agents in the past sort of 2 years already implement this, where they're obtaining the rates and water searches from their vendors and then are including it in their sale information. So I don't think this is really anything different to what they've already been doing as well. It's just effectively that it's inserting a date range.
And say you do an old rate search, not the most current one, and there's like I think the Mackay Regional Council said there's a 4.7% increase, right? So the old one is 4.7% less.
Yep.
Right? Are there any consequences?
I don't think you're going to have a buyer that's going to be able to ever say, I'm materially prejudiced because council increased the rates.
It's subject to CPI like everything.
Yeah, that's right.
So,
and I think one thing to point on, this isn't requiring agents or sellers to actually do a formal rates or water search like we would do as a solicitor. They can just obtain their most recent bills. And my recommendation has been, well, fill it in, but you can attach it as well. So of course, if you got it wrong or there was other information on there, you can just attach a copy of it to the disclosure statement. But again, you can redact that privacy information as well from it. You know, there's nothing wrong with you blacking out the seller's, personal details before you attach it, if that's your preference as well.
Yeah.
So.
Just on that point, if you're attaching documents, can you just say, instead of filling out amounts and stuff, can you just say, see attached rate search?
Look, you can, but we're all human. And so the risk, of course, is if you write see attached and then all of your admin staff and your docu-signing it, someone forgets to attach it.
Or the scanner misses that page.
Then we've got a problem. So certainly I think attaching it is great, but you've got to fill the information in as well.
So body corporate information, and I'm going to say this has been a bugbear for agents ever since I practiced, which is a long time now. Run us through the changes.
Well, my advice actually has to be to most agents is after the 1st of August, just don't sell any units anymore. But obviously that's not practical. I completely understand that that's not practical. I think one of the good things that has come in from this is that when we get to our contract stage, we don't have a separate disclosure statement that is going to go with the contract. So for a unit, you'll have the seller's disclosure information with all of your attachments with it and your contract of sale, but we don't have a separate body corporate document that's got to go with it. So it will all just be obtained in this. So in some respects, that's good.
Well, I guess also from the perspective of the body corporate disclosure that's being given is now being provided by the body corporate managers. So if there's a professional manager involved, they're providing all of that information and they're actually signing off on that part of the disclosure statement. So it's not going to be that double-handed situation where we currently have, where there is a professional manager, they complete the form and then you've got to lift it into a Section 206 disclosure. So it's just going to be one form, one request, they complete the information and then it comes back to you.
So Lloyd, what if there's no professional manager?
then it's a little bit more interesting. There is a separate form for self-managed properties, and there will be some additional questions that will need to be answered and statements provided by those owners where there is no professional or functioning body corporate.
So that's right. We can go through and we can explain, why we can't get this information. That's right. There isn't a professional body corporate. Or, it's not functioning. If it's the situation where there is certainly a functioning body corporate, but they just self-manage it, then they can complete, because there will still be a secretary appointed of the body corporate of those owners. So in that typical situation, you might have the 4 units that are self-managed. Unit 1 may have appointed themselves as the secretary. They can complete that information as the secretary of the body corporate, sign it, and we attach it to the disclosure statement.
So I guess from what you're saying is, in 90% of cases, the process has probably been simplified a little bit. So it's easier, right? And the 10% of cases where it's no body corporate manager, maybe not there's a 2-unit scheme, it's going to be the best is to contact the solicitor and say, what do I do?
Help. Yep. That's exactly right. So, and it's a standard form that you're just going to go through in, like the disclosure is. It's a standard body corporate form that you go in and you fill the information in. So.
What about Bugger?
Well, I was like, we actually have one close to us here in Mackay. So our Laguna Keys lovely development, if anyone's aware of that, is a BUGTA scheme. It will just require some additional information to be disclosed in its sense as well. I wouldn't be too concerned about it. There are very few and far between BUGTA schemes.
And there's on Bridge Road, Ocean View?
Oh, there is one on Bridge Road that is a BUGTA scheme.
Right next to the resort.
Yep.
Right.
For the agents, for you guys, probably to understand, like the BUGTA one is an old body corporate scheme that was pre the current body corporate legislation that came in 1997. So that's an old scheme. Most of the body corporates did actually transition after 1997 to this current legislation that we've got now, but you will find some that haven't transitioned.
Yes.
The easiest way to often know if it was one that didn't transition is there's no CMS noted on the actual title search for you to actually do. And you'll look at the actual plan and it will be noted on the plan that it is under this old piece of legislation. And then you're going to know, okay, I don't fill in the community title scheme section on this, I fill in the BUGTA scheme on this instead. So
now, I remember from my days that they had BUP, building unit plans, and GTP, group title plans.
Yep.
And in the transition from those, and they're now all come under the
Body Corporate
Communities Act, the community management statement. So that's a little bit tricky, isn't it? Lloyd, do you want to talk us about if something came under the old BUP or GTP, how do you provide a community
management statement? Well, generally speaking, there is if they haven't adopted or they haven't passed a resolution to adopt a community management statement, then there is the legislation. So the legislation sets out the standard bylaws that are to apply for those schemes that haven't adopted a new community management statement.
So when you're providing the CMS, if it's under the old BUP, GDP, you provide maybe a copy of the plan.
Yep.
And the statutory bylaws.
Yep.
Signing the form. All right. Can you run us through? Because I noticed there's a bit for the seller to sign, obviously.
Yep.
And there's a bit for the buyer to sign. Who actually has to sign it? And what happens if we get this stuff wrong?
So from the seller side of things, seller has to sign it. In theory, the agent could sign it on their behalf, but we're never going to recommend that.
No.
We're going to shift as much liability from the agents to the seller direct. So as an agent, you're always going to get your seller to sign this information personally. The seller has to sign it before the contract goes to the buyer. So from the seller side, has to sign it before it goes to the buyer.
Think of it like it's the old body corporate disclosure. It has to be signed by that seller before it goes to that buyer. Otherwise, it's just, it hasn't been, it's not valid. So.
And is the buyer required to sign it?
No. So while there is provision for the buyer to sign the disclosure statement, it's more of a best practice, again, to say that they acknowledge that they received the disclosure before they sign the contract. However, there's no legal requirement that it does need to be stated. And you're going to have ways that you're going to prove that you have provided this to your buyer before they sign the contract, generally via email, which will have a time and date stamp, or in your DocuSign envelope, which I'd always recommend that your disclosure is going to be at the front of the contract.
And I remember there was quite a well-known case where I believe it was a disclosure statement that you had to give. And once again, the disclosure statement, the buyer didn't need to sign it. And the buyer did sign it and then said, we're able to show that they signed the contract or received the contract before they got the disclosure statement. And I remember the judge saying, well, I don't really need to look at that because you signed the disclosure statement acknowledging you got it before the contract. So I'm going to rely upon your representation that you got it before. So bad luck, you don't have a right to terminate. So I guess that's a lesson to, yes, if you can get the buyer to sign it,
Great.
get them to sign
Get
it.
them to sign it, definitely.
Now, I noticed in the form, there's a few sections where there's not a box and there's just almost like a warning statement. And an obvious one is flooding and there's one about vegetation. Why is there not a box to tick?
Well, I guess the regime's gone the way of saying, well, you don't have to disclose this, but you're directing the buyer to places where they might be able to find that information. And generally speaking, those resources are available online and free. So it's more along the lines of, if this is a concern for you as a buyer, then here's the direction to the relevant resources and you can go have a look at that for yourself. And it's going to be different for each person. Some people might be happy with a risk of flooding because realistically, let's be honest, these days there can be a risk of flooding in any area. It's just dependent on whether or not that level of risk is something that you're personally comfortable with.
So flooding, and this is a very popular one, particularly in Brisbane, which seems to flood regularly.
Yep.
There are two questions or two scenarios that come to mind. One is, okay, the seller hasn't made any representations, right? Contract signed, obviously the buyer gets this form which says,
Go and check it out.
Go and check it out.
Then before settlement, the buyer finds out, oh, hang on, in 2011, this property flooded, right? Any recourse for the buyer?
No.
Yep.
There's been no disclosure to say that the property did flood. It's just effectively given the buyer the information needed to go and make those inquiries themselves.
So the second scenario is, this time the agent has disclosed was not affected by flooding in 2011, which was false, and I'm going to suggest that they were told that by the seller, weren't aware of it, so they've made that. Does this statement in the form absolve of liability from the seller?
No. And I think that's the important thing to note in this form is that there is a lot of information that this doesn't cover off on, and the agents still can get caught from misrepresentation claims about other aspects and claims, of course, that they're making. Just because you've put it in here or not put it in here, it's not going to completely absolve you from any misrepresentation claims. You still need to be careful on the information you're giving to your sellers, how you're advertising the property, and ensuring you're giving that information correctly.
Yeah.
And I think this is probably useful for agents, because now they've got an excuse. If a buyer inquires about flooding, they can say, look, on the disclosure form it says you should make your own inquiries. I direct you to make your own inquiries.
Yep, full stop.
Yep.
And there's going to be a lot of those things in here because obviously the form doesn't touch on structural soundness of the property, historical uses, those asbestos even, so the form, there's lots of gaps in here. So
anything
we still
related to building and pest is still a separate buyer's inquiry that they're still going to do as part of the contract. So it's only the information that can be gathered and probably has always needed to be disclosed. It's just about bringing it to your seller's attention and putting it in a form and presenting it to a buyer. Whereas previously, the rights that are contained within this in terms of termination were probably always contained in the fine print of the REIQ contract. It's just that there was nothing turning a seller's mind to
having to provide
it before
Yeah.
a contract is signed.
Now, we were discussing off air a question about agents preparing forms and, what's the liability? So I know from my day, this isn't the first time we've had to do disclosure statements. And what we're anticipating, and correct me if you have a different opinion, is that initially agents are going to maybe outsource it.
Yep.
But 2-3 years down the track, certainly on the straightforward residential properties, we think that
It'll probably come back in
the
house.
agents are probably just going to be doing it
Yeah.
to save money. So let's look 3 years down the track,
Yep.
and 90% of agents are preparing them themselves. What potential liability does the agent face?
Obviously, we're trying to off-risk it for the agents as much to the sellers. So you're trying to be getting as much information as you can directly from the seller. So of course, if the seller gives you the incorrect information, you can't verify it. Seller's given it to you, the form's incorrect, buyer terminates the contract of sale. Well, the seller's given you that information. You've taken it. The seller's not going to be liable for the loss that the seller is then going to suffer because the information was incorrect.
And just on the buyer terminating the contract, they've got to do it before they settle. So it's not going to be a claim later on down the track. It's they've terminated this contract, and then any liability is really going to be associated with the resale value of the property thereafter.
So in my situations, one, the seller's signing the form, so they're responsible
Bill.
for signing it. Second, even if the agent prepares it, they're preparing it from information given to by the seller. So if the seller gives incorrect information, they've got no recourse against the agent.
Yep.
Right? But let's look at worst case scenario. Seller gives the information to the agent, and his office girl
Stuffs it up.
stuffs it up, right?
We're all human. It's happened.
And contract was 1.5 million, falls over now. The best they can resell it is 1.3 million.
The agent's going to be liable, but that hasn't changed to what's going to happen now. If you stuff up your contract now and the information, that's the exact same situation that you're going to be in now. So I don't think agents should be horrendously nervous thinking that this is an additional liability that they're going to face, because they're still going to be preparing contracts of sale, preparing Form 6 documents, all of those they're still going to prepare, and you can just as easily stuff up a Form 6 or a contract of sale and get it wrong and lose the deal.
A big one that's
then over
always
the disclosure.
been a problem for that is rentals. So if rentals are recorded incorrectly in the contract, then the buyer says, my yield's not going to be as good for that property, and before settlement they say, well, I want a price reduction because you told me it was getting $700 a week and it's actually only getting $670 a week. So those typos exist. Unfortunately, we're all human, but it's not really creating any bigger risk.
So the form's not really increasing that, because that risk always existed.
Yep.
And of course, on the form, the disclosure statement, the buyer has to be materially prejudiced, and the real risk is a claim after the event when they've bought it, isn't it? Not that they terminate.
Yep, 100%.
And I guess that goes to then making sure that if you are attaching all the documents, then if it is incorrectly stated in the disclosure statement, but you've then attached the relevant direct material, the buyer has received it. So there's going to be a harder argument to say, well, you received the actual rates notice. If the junior in the office has put the wrong rates amount in the actual disclosure, but you received the actual rates notice, well, the buyer still received the correct notice. So it's going to be harder to make that argument.
You touched on something interesting there, Roland. We're talking about after settlement, and I think that's something a lot of the agents that I've spoken to, and I think Lloyd's the same, they're a little bit worried, well, if there's something wrong in this, but the buyer has settled, what comeback is then going to happen after settlement to the agents as well? So is that something that you're finding as well, Lloyd?
Yeah, but essentially it's probably one of those things where the buyer's rights are up until settlement. We're still in a quasi buyer beware system. While this changes it a little bit, we're still in that system. So as soon as it settles, then effectively your liability comes to an end.
So to wrap it up, guys, 2-3 years down the track, maybe 5 years down the track, do you think things are going to change?
Depends what government we've probably got in, actually, will be the big one. I think from my side, and I'm not sure, Lloyd, what your opinion is, but I think it's either going to go one or two ways. That the first way, everyone's going to get so used to it that so much it's just literally going to be a tick and flick. Tick, 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 attach the documents, we're done, and that's all it's going to be. And we may find people get a little bit, sort of really less worried about it. And it's just yeah,
Becomes
we've got to
second
do it.
nature.
Second nature, we do it. But it will be very interesting to see if it goes the other way. And this is more the start of it. And we're going to start increasing more disclosure obligations. And do we need to do building record searches and those sorts of information as well, to sort of bring us in line with some of the other states to take us to sort of that national conveyancing and property law scheme.
Yeah, a regime where everyone is on a similar basis, because at the moment all the states are quite different in what they're doing, and I guess this is probably the biggest step to go towards the New South Wales Victorian sort of stance, but it's still not all the way there. So it's a level of to whether or not Queensland will adopt that much stricter and more and larger disclosure requirements, or they'll be, this is enough and we're happy with it and it stays the way that it is.
Yeah, look, my view is, having been in the game a little bit longer than you guys, I've seen a few disclosure regimes come in and then there's been such a backlash, they've been removed.
Yeah.
And the RAIQ is quite a powerful lobby group.
Yes.
But the other group, which is probably even more powerful, is the insurance groups.
Yeah.
And the previous regime was causing all sorts of problems, and the insurance companies were getting a lot of claims, and they went, right, we've got to stop this. So I think, like you guys, that it's going to end up being a tick and flick. It's going to be fairly straightforward. I don't think there's going to be a liability problem, so the insurers won't get involved. I think as long as the agents get very comfortable doing them, I don't think it's going to change, even if we do get a change of government. In terms of will we end up closer to New South Wales, Victoria, WA, those regimes, I don't think so, because they do an exchange of contracts, whereas we don't.
Yeah.
We sign off at the start and then we have the conditions later on. Everyone I speak to in Queensland, all the very experienced solicitors, every seminar I go to, they all say the same thing. We tried New South Wales system of exchange. It was a disaster. We don't ever want to go back.
Yeah.
So I kind of think, in 10 years' time, we're going to have pretty much the same system. There might be tweaks to it, but I think it's going to be the same.
Well, it is the first change since, 1974 to the Property Law Act, so I'm like, it's been a while coming. There's been other disclosure regimes in the meantime, but I'm like, it is a substantial change.
And that change, like I read the initial report from the authors, Sharon Christensen and Bill Duncan, I think there's a couple of others, that started, God only knows when, but that report came out in 2018.
Yeah.
And certainly where we've ended up is nowhere what it was looking like at the beginning. It's really been scaled back to what we've ended up with at the end of the day now.
So even if they decided to change it again, given it's taken us 7 years from when the report was, and let's say it took 2 years to do the report, right? That's 9 years. So even if tomorrow they said, we want to change it, you're looking 9 years down the track. And so realistically, it's not going to change in the next 10 years.
Yeah.
Well, I'd like to thank Bethel and Lloyd coming on to Property Chat with me. It's been really great to hear your opinions and really informative. I think anyone who's preparing contracts is going to get a lot out of it. So thank you very much for coming on Property Chat with me.
My pleasure, Roland. Thanks for having us.
Thank you, Roland.